Hello everyone, this is Neha Pellegrino, Senior MSP Compliance Counsel, and I wanted to take a moment to welcome you to the ECS on MSP podcast. As you all know, ECS is dedicated to assisting you navigate all the complexities of MSP compliance, but we believe that compliance shouldn't be static. The rules evolve, technology evolves, and the way people consume information evolves, which is what led us here. While we've been continuing to connect with you through our monthly webinars, which we love providing, we recognize that this industry moves really fast, and so do the professionals working in it. So the idea behind the podcast is about meeting you where you are by delivering content in a way that fits your schedule. And we're really excited to have this be a part of our ongoing commitment to share knowledge and support you. Each episode will bring you practical insights and real-world discussions, all in a format that's easy to listen to and easy to learn from, almost like you're sitting on the couch in our office. So whether you're here to stay compliant, deepen your understanding, or just hear from the voices that live and breathe this work every day, you're in the right place. That being said, let's get started. So for today's session, we're really going to just get back to the basics in terms of conditional payments. A lot of times we see conditional payments treated as an afterthought, and that can happen for a lot of different reasons. So, our goal here today is to provide you with knowledge and awareness to change that. So going through today's rundown, we'll start by diving into just some background terms and describing the role of the recovery contractors. With that, we'll also discuss some of the differences between Medicare and Medicare Advantage plans. Then we'll walk through the recovery process and explain several dispute and appeal tactics. And something that has been somewhat of a recent hot button issue, we'll talk about pre-settlement strategies and walk you through a checklist of items to underscore prior to finalizing your settlement agreement. And finally, time permitting, we'll take any specific questions that you all have and answer them live here this afternoon. So let's jump right in by describing what a conditional payment is. So this is a payment made by Medicare for services where another party is the primary payer. Right now, conditional payments can be made by either traditional Medicare or Medicare Advantage plans or Part D prescription drug plans. So here on the slide, we have a classic example, if we're following the orange arrows, of an individual that's a Medicare beneficiary who's injured at work. That beneficiary seeks medical care, and then Medicare pays for that payment on the condition of being repaid, hence the term conditional payments. So the overarching public policy here isn't to hinder people from receiving medical care, but rather to deal with coordination of benefits on the back end. So then Medicare will look to the primary payer, in this example being the work comp carrier, to reimburse them for those medical payments. Those blue arrows are following a different workflow where you have either a denied claim or a liability claim where the carrier is not taking responsibility for those payments. But if we can jump to the next one, in seeking repayment, Medicare has two recovery contractors. So they have the BCRC and the CRC. So I think it makes more sense for me to start on the right-hand side with the CRC, and that is because with the CRC, you're dealing with recovery on admitted claims. So these are your work comp or no fault, ORM yes claims. These are pre-settlement recovery actions where the debtor is identified as the RRE. And it's important to note that there is rolling recovery here. So multiple recovery actions can be created over the life of the claim where you have ORM that remains open. So now if we move to the left-hand side with the BCRC, these are going to be your ORM no claims. So these can apply to work comp or liability claims. So that is post-settlement recovery actions for work comp claims, or pre or post-settlement recovery for liability or denied claims. Examples here would be where you're performing perhaps a proactive conditional payment search for a denied claim, or where you're retrieving a final demand for a settled work comp claim. Because of how these are issued, the BCRC generally will default the debtor as the beneficiary. So, in doing a final sweep, this is sort of your chance when TPOC occurs to procure that final demand, to ensure that there's no surprises down the line. Speaking of surprises, I think if we move to the next slide, I'd be remiss not to discuss The fact that, if you have a beneficiary that is treating, the carrier's not been billing for that treatment, you receive a $0 final demand, that could be an indicator that the party should look into, Medicare Advantage liens, right? Because someone's making those payments. So let's talk a little bit about Medicare Advantage plans. So a Medicare Advantage plans are offered through private insurance, not the government like traditional Medicare would be, right? So for beneficiaries, the goal here is to provide an alternative to Medicare or even a supplement to Medicare. So it's relevant to point out that an individual can enroll in both Medicare as well as a Medicare Advantage plan. And recent stats show that over 50% of Medicare beneficiaries are enrolled in MAPS currently. So these are really prevalent plans. So how do you know if an individual is on one of these plans? Because there's no central database, right? Like there is with, Medicare. But the PAID Act, which recently came into effect back in 2021, requires Medicare to provide MAP enrollment information through the query process. Now, it has its limitations. It only shows the last 3 years of enrollment, but being able to run these types of queries is beneficial given how widespread these plans are. So, Michael, do you want to discuss a little bit about, how MAP plans or Part D plans are handled differently than Medicare, traditional Medicare, that is, when it comes to recovery efforts?
Yeah, absolutely. Thank you, Neha. So I think it does make sense to just kind of pause on Medicare Advantage plans just because we're going to be talking about a lot about the Medicare system and Medicare Advantage. If we're talking about Medicare being, the ultimate lien holder, they are 1A as far as who gets paid first. Advantage plans and Part D plans are 1B. And if you get verification from Medicare on something, it in no way means that they're representing Advantage's position on the same thing. So, just historically speaking, this used to be kind of a gap in terms of the only way that insurers would know that there would be an Advantage plan in existence was if they asked the beneficiary and the beneficiary said yes or no. If they said no, then they wouldn't have any idea if they were accurate in that representation. So the PAID Act kind of filled in that gap. So back in 2021, CMS said, look, we're going to tell you exactly when this person was enrolled over the last 3 years and what plans they were enrolled in. So if they were involved in, 2 to 3 different Advantage plans over the last 3 years, you will now get that enrollment data with the query process. As far as what those Advantage plans were, they just give you an address, but they'll tell you what plan, what time period, and the address as to where you can reach out and try and put them on notice if you are reaching settlement. So that you are considering Advantage plans and Part D plans when you are settling your claim, just because they do act independently of Medicare and they just don't follow the same process. If we go to the next slide, we'll kind of get into what some of those nuances are. Specifically, they're private companies, like Neha was saying, so they don't have to follow the same rules as Medicare. In fact, if you reach out to one Medicare Advantage plan and then you reach out to a different one, you may have a extremely different experience as to how that process went. You might have an Advantage plan. I'm just going to throw out examples here. Don't take this as this is how these plans act. But let's say you have Humana. They may be responsive. They may say, yeah, here's our interest. They may give you a timely response, and they may be very cooperative in working that out. You may also have a different experience where maybe you have a collection agent that's acting on behalf of an Advantage plan, and they are obstinate, they are litigious, they are not willing to be flexible or negotiate. So it's really kind of all over the map. And also, these Advantage plans have no obligation to respond to you, period. So if you say, hey, Advantage plan, we're trying to settle a claim, do you have any interest that we need to consider? You might get crickets. They may never respond to you, and I get that that is frustrating. It doesn't give you the closure approaching the settlement. That said, it's still important to do that, because if you don't get a response from the Advantage plan, they do have a statute of limitations that's going to be applicable to them as far as when they can actually bring a claim for their interest if they are going to do that. I wish I could give you an exact number, but it's really not settled law at this point, depending on the federal circuit. It could be anywhere from 3 to 6 years. sometimes 4 years. So it's really kind of all over the map, but it is important just to put them on notice, try to get them involved, because if they are going to bring a claim later on, if you said, look, we put you on notice and we tried to resolve it and you didn't respond to us, it makes it a lot harder for them to say you should pay us double damages if you're trying to basically initiate some type of involvement with them early on. As far as if we move to the next slide, I think it just kind of makes sense to talk about really what kind of these differences are between traditional Medicare and Advantage, because as I kind of mentioned, Advantage plans can be all over the map. They are different private companies that are acting independently. And then you have Medicare. Medicare is extremely structured. They have built this process out and they say, this is the way it's going to go. If we are recovering specifically on Part A or Part B, you know, and we're going to get into what that process looks like, but you have a lot of time to respond. You have a lot of different bites at the apple, so to speak, to try and defend against any conditional payments. And they also just have a very robust appeal process and even access at the court level if you aren't able to informally deal with it with CMS. Also, the Treasury offset program. So if Medicare doesn't get the payment that they think is owed for conditional payments, what they will do is they will refer this debt over to the Department of Treasury. That's generally a bad thing, because if it goes to Treasury, Treasury is just going to take what's called offsets. And what that looks like can be different for depending on who the debtor is. So if the debtor is the underlying insurer, what a Treasury offset is going to look like, let's say there's a conditional payment of $100,000. And for whatever reason, it just goes unnoticed or it doesn't get paid. What Treasury is going to do is they are just going to find a wire transfer from that company and snatch the money out of that. Doesn't even matter if it's from the same part of the company where that work comp liability, no fault, wherever that debt originated. They can just take a transaction from anywhere else. And it's kind of a nightmare when that happens. So you want to kind of resolving these before it gets to Treasury, just because that's how Medicare and CMS are going to operate as far as resolving those debts if it's not done voluntarily. The Advantage plans, on the other hand, litigation is kind of their recovery method. They can't go to Treasury and give the debt to them. So that's why you see these private cause of actions for double damages. And you're going to see a lot of action from recovery agents or law firms that are bringing these actions on behalf of them. One of the other big differences is Advantage plans. You can actually negotiate some of these conditional payments. It varies. Some companies won't, some companies will. Medicare is very binary. It's either do you owe the conditional payment or do you not. The Advantage plans, they might have a little bit more wiggle room to say we'll accept a lesser amount. We might accept 75% instead of 100%. So you might get more of that negotiation wiggle room. And there could be some regional differences as far as how those claims are handled as well too. To kind of move more into the Medicare side of things as far as what that process looks like. On the next slide, we kind of just have this flow chart as to really how does that work. So there really are a lot of different levels and timeframes in order to deal with these conditional payments. The first one we have is conditional payment letter. A lot of times you are going to get this letter when there isn't actually a conditional payment that CMS is going to be asking for yet. So a lot of times you see the letter on, let's say you have a denied claim and you're reaching out saying, hey, we're going to settle this denied claim. We want to know what's out there to see if we have to resolve it. Until you actually settle that denied claim, Medicare hasn't perfected their interest as far as being able to ask for the money back yet. So they're just saying, hey, here's the conditional payments we've identified. If you want to submit a dispute, you can. You don't have to issue payment yet. You can wait until that point of settlement. So obviously that conditional payment amount can go up over time. So if it's been a while, you might want to update that prior to settlement, just because CMS can coordinate benefits all the way into that point where you do close the claim. But that's kind of the initial step. Next one is a notice. You're going to see this when CMS is probably actually moving towards actually asking for the money back. And again, there's not a whole lot of consequence to ignoring this one. It is a level of disputing where you can say, we don't think, and you're still going to get more chances to dispute that later on. But this notice here, you have 30 days to respond to it. So, 30-day window. Again, there's no real consequence if you miss that, other than you miss kind of another bite at the apple for disputing this conditional payment. but you can issue payments if you say, yep, we agree these are related, we're going to pay them off. The next step is CMS is going to issue a demand. So if the conditional payment notice isn't fully resolved, they say, now we want you to pay us back this conditional payment. So you have 120 days from that demand in order to file an appeal. So if you're counting the time period so far between a notice and demand, you have up to 150 days. So a little less than half a year. So you have quite a bit of time to actually deal with these and resolve them. After the first 60 days from that demand, interest will start accruing, and I wouldn't sleep on this because the interest is pretty high. It's not like mortgage rates. It's usually north of 10%, at least over the past several years. So that interest level is going to be significant, especially if you have a higher conditional payment amount. And if your process goes beyond 60 days with the appeal, like that interest is still running the entire time. There are ways to mitigate that, such as paying and saying, we're not agreeing to this, but we're just paying to it just so we're not accruing interest during this appeal process, and you can get that refunded. Some people choose to do that, others don't. Others don't want to pay until they have to, but just know that that interest will start running if the debt is still out there. Once you get further along in the demand phase, you may get an intent to refer letter. This isn't really a new demand. It's basically just saying, hey, you don't have much time left. We're going to refer this over to Treasury if you don't submit an appeal or we get this thing resolved. So that's kind of your reminder. You need to get this done. Otherwise, you're at risk of going to Treasury. Finally, after 150 days, again, you only have 120 days to submit your appeal, but after the 150-day mark, CMS will send that debt over to Treasury. And that's when you're at risk of an offset from the Department of Treasury. And the other thing to note is once it gets to Treasury, you lose a lot of ability to informally deal with CMS. So if you say, we want to argue that these conditional payments weren't related, it's kind of too bad. At that point, CMS said you had your time period to submit an appeal or dispute and you didn't do it, so we're not going to listen to it now. So there are some ways that we can creatively get that back to get CMS to listen to those arguments depending on the situation, but there are other times we can't, and then you might be stuck with that debt and have to take it to law judge or kind of more formal hearing and litigation at that point. So you want to try to avoid Treasury, and I'd say if there's any kind of takeaway from this entire timeline here is once you get those notices, respond to them timely. If you don't agree with them and you don't think you owe it, whether you're using ExamWorks or somebody else or handling it internally, make sure you are reaching out to CMS and saying, here's our dispute, here's our appeal, and do it early so you don't have interest running up. Specific to liability claims, there is one unique method you can do to resolve conditional payments, and I'm going to let Marty talk about that one just because it's a little bit different than this kind of formal process because it's kind of its own thing.
Yeah, so thanks, Michael. So we can go on to the next slide and we'll talk through the fixed percentage option. And it's really an opportunity. It's really fixed percentage opportunity. So on the disputes and appeals that Michael's talking about, you think about looking at all those letters as they come along, and Neha's going to get into some of the details about how we go about looking at them. Each of them is basically looking at a line item, an individual line item, and explaining to CMS or the contractor why it is that you're not responsible for that particular line item. So it's just one line item, and then you might have 100 line items that you're going to try to dispute, and it may be all for the same reason or maybe all different reasons. But each of them is its own little distinct dispute or appeal, right? So the fixed percentage opportunity is a little bit different, and this is something that only applies in liability cases, and it's designed to help resolve nuisance value liability claims involving Medicare beneficiaries swiftly and without the need for a lot of back and forth, and without making sure that, without having to delay settlement potentially and delay giving, a small amount of money, relatively speaking, but maybe a difference making amount of money for that particular individual, their money quickly. So basically the option is there in these circumstances to resolve Medicare's interest in conditional payments, to resolve the conditional payment matter by just simply paying a flat 25% of the total settlement over to Medicare. The requirements are pretty simple. So if your claim falls within these categories or this particular set of requirements, then you can elect, or the beneficiary, technically speaking, can elect to go through the fixed percentage opportunity, right? So here we go. So first one, it has to be a liability case, not a comp case, not a no-fault case, a liability case. It has to be a single event liability settlement. So think about, for example, we've got a slip and fall in a supermarket. That's probably pretty common. Relatively small nuisance value settlement with a Medicare beneficiary. Slip and fall in the settlement, we're going to slip and fall in a supermarket rather, and we're going to say that it's a $10,000 slip and fall, right? That's the value, and that falls within the category because it has to be a liability settlement. That's a single event settlement that's $10,000 or less. $10,000, that qualifies. Now, prior to the settlement, before the settlement, or today, if I'm going to settle the case today, I cannot have told Medicare that we've already settled the case. I can't have already received a conditional payment demand, and I can't have already received a conditional payment notice. So if that's the case, let's say I'm settling a claim with a Medicare beneficiary, or better yet, I am a Medicare beneficiary, wanted to settle my case, and I want to reach a $10,000 settlement with Acme Supermarket for my slip and fall claim. I may have known that Medicare paid $10 trillion for my treatment. Now, of course they didn't, but they may have paid $12,000 for my treatment. And I'm looking at this and I'm saying, wait a second, if I settle this case for, $15,000, then Medicare is going to take $12,000 of it, and I'm going to be left with nothing, maybe $3,000. So why would I do that? So I can resolve this case quickly. I can make sure that Medicare gets their money, but I can also make sure that I'm able to walk away with something by settling this case for 10. And that's sort of the idea behind it, right? Because it allows Medicare to get their money. It allows you as the beneficiary to get your money and get rid of the case without having to deal with a lot of back and forth, because that's what we want to avoid here is the back and forth. And these are relatively small cases. So if that's the case, I'm settling my case for $10,000. I haven't received a demand. I haven't told Medicare about the settlement. And yet there's also no other settlements, right? So I'm not going to settle with Acme Supermarket. And then I'm also going to then forget about the fact that the Jiffy Lube truck left a big oil spill right there that I stepped into, right? So it's the supermarket didn't clean up and the oil truck left the oil. Well, I could sue both of them, right? Well, in this case, I'm only suing one, and I'm only going to have one settlement. If that's the case, then I can elect at that point to go through the fixed percentage option. Now, if you look on the right-hand side of your screen, you'll see there's a form. That's the model form that's created by CMS. Technically speaking, the beneficiary goes ahead and fills this out. And the key is the beneficiary must elect. It can't come from the carrier. It can't come from the claims payer. It has to come, the election technically has to come from the beneficiary. If that's the case, I'm settling my case for $10,000 and I'm the beneficiary. I can take my $10,000, I can fill out this form, I can sign it, and I can take a $2,500 check and I can send the $2,500, which is 1/4 of $10,000, over to Medicare, and that will take care of everything. They're not even going to get into the fact that they pay $10,000, $12,000 for medical in this particular case. Right? If you do the math on it, Medicare would recover a lot more, obviously, if I were to settle the case for even $1 more, right? In this case, so this helps everybody involved, and it helps to sort of grease the skids of justice and allow us to be able to move these cases faster through. From a liability claims handler's perspective, this is an opportunity, right? Because while it's the case that the beneficiary must elect to do it, there's no reason why you as the liability claims handler can't help facilitate this, right? You can fill out the form. You can work with the beneficiary to try to make sure that they're aware of the fact that this is an option for them and that they can sign it. And then you can be the one to actually cut the checks. You can cut the $2,500 check over to Medicare and the $7,500 check over to the beneficiary, and make sure that that election form gets in the mail and gets to the proper folks at the Medicare contractor. Huge opportunity. We don't think that enough people do it, honestly. We hear about it. We know that there are a lot of organizations that have it within their claims handling guidelines to utilize the fixed percentage opportunity, but we don't see it as often as we would probably expect to. And I'd say that for some of the smaller, medium-sized liability organizations out there that may not be as aware of it as some of the larger organizations that have more of an advantage of it. So it's a huge opportunity out there. If you have any questions about it, obviously you can feel free to email any of the folks on this call, and actually we'll get to the contact information at the end of the presentation. But this is a big one, and certainly one that's underutilized. With that, when we think about the other cases and we think about the line item disputes and appeals, well, we have to get right into the appeals process, right? And so Neha, I'm going to turn it back over to you, and as we go on to the next slide, we're going to turn the appeals process back over to you.
Great, thanks, Marty. Yeah, so we're going to jump into conditional payment appeals. And so there's a 5-level formal appeal process. And this differs from, the informal disputes in response to CPLs or CPNs that Michael discussed in detail earlier. This is really, it's that demand stage that triggers this formal appeal process. So when we're looking at this first level or the redetermination stage, this is an appeal that's sent back to the original contractor. So that being, the CRC or the BCRC. And then at the second level, with this reconsideration, these appeals go to an independent contractor. So there's a full review done at this by, what they call, QICs or qualified independent contractors. So if you're at this point, the more records or documentation that you have to bolster your argument, the better. And if that's not successful, you can file a hearing, with an administrative law judge. And then for those 4th and 5th levels, it would be, medical appeals council, and finally, federal court appeal. So I'd say levels 4 and 5 are pretty rare. We do see some, ALJ cases in office here, which we're happy to assist on, should it get to that level. But when drafting these appeals, there's, various arguments that can be utilized. A lot of times we just think of, something not being related, but there's so much more than just that. So I'm going to tag Michael back in here, as he's, very proficient in this space, so he can kind of walk us through some of the common dispute types and tactics.
Thanks, Neha. Yeah, with regard to administrative law judge hearings, at least the ones ExamWorks does, I rarely see them. Like I have one coming up, and that's going to be the first one in quite a long time. And the reason is CMS gives you so many opportunities to deal with this before you actually get to that administrative law judge, and we're able to resolve 99 point something percent of these with CMS before having to go to an administrative law judge. And I think that's more an attestation, not only to are we effective doing this, but CMS is willing to work with you and be reasonable in most cases. So I think that's why you want to deal with it before kind of that formal hearing process if possible. But as far as, let's say you got a conditional payment, we'll move into the next slide here, where it's just, these are the things that we would consider some tactics or best practices. I mentioned this before, but number one, you have to respond time. If you miss your window to appeal, it's really, you are missing opportunities to deal with this at an informal level. CMS, you are missing opportunities to reduce exposure to interest that is going to accrue on that debt. So making sure that if you get a conditional payment, you don't let it sit. If you are sending it out to someone like ExamWorks, make sure you're doing that and letting us know early so we can get a jump on it and make sure we are getting those deadlines met. Because again, if you miss those, then you're with Treasury, then everything kind of goes downhill from there. But as far as just some general things here, the number one is identify why you got that conditional payment to begin with, because it's not always because it's something that you owe. There's a number of reasons why. Like CMS's algorithm for these conditional payments is based on what is reported to them. So they're going to look at not only the ICD codes, and their algorithm with regard to the ICD codes is a very hit and miss. Like we'll have a back injury, and all of a sudden they're saying, oh yeah, this treatment related to sleep apnea is included in the conditional payment. Sometimes it doesn't make sense, and we're going to dispute those. But sometimes it's like, well, we settled this claim. Why are we getting a conditional payment? And then you look and you find out, oh, my Section 111 wasn't updated. I didn't report an ORM termination or something like that. So starting with kind of a root cause analysis as to why am I getting this conditional payment is usually a good starting point. And For the clients that we do the Section 111 up automatically. If we don't, you send it over to us. We may ask for a screenshot of the Section 111 reporting just so we can make sure. Can we prevent you from getting conditional payments in the future if there needs to just be a simple update? I'll kind of touch on these areas later, but what used to happen is maybe 5+ years ago, we used to just be able to send in an appeal saying, oops, we forgot to enter in a termination date. We forgot to enter in a TPOC, something like that. And CMS would say, okay, update the Section 111, we'll move on. They've gotten quite a bit more strict now. Now, if you say we made a Section 111 reporting error, they may ask for receipts, so to speak. They may say, oh, you settled the claim, send in the settlement documents to show that. If you denied the claim, they may say send in the denial letter. They may say send in a payment ledger in some cases, or you send in the policy documents. So it's not quite as easy. You can still deal with these, but they're going to make you do more legwork in proving your case if you're submitting these now, if there was some sort of incidental Section 111 reporting or omissions on that side of things. I also mentioned before, CMS is sometimes going to say, you owe us money, and you look at the conditional payments and you're like, this is in no way related to our injury or our incident. That is, I would say, the vast majority of the conditional payments that we're disputing. I'm sure Neha and Marty have seen a dozen of these where it's just like ridiculous on some of the things that they're asking back on here. And some of those are easy. What it looks like when you get these conditional payments is CMS just sends a payment summary. It shows the provider, it shows the date of service, it shows the CPT codes, and it shows the ICD codes. And there's a number of different ways that CMS can be inaccurate here, specific to the ICD codes, because this is primarily what they're looking at. They're not looking at the medical records and saying this looks like it's related. They are doing this purely based on the line item billing with these ICD codes and CPT codes. So one thing you may see is what we call unlawful bundling. There's some case law specific to this, but kind of the gist of it is you might have a provider that enters in multiple ICD codes for the treatment in question, and sometimes they add in secondary ICD codes that don't speak to what was actually treated, but more comorbid conditions that were factors in considering treatment. So you might have something where the person went in and you have an accepted back injury, and all of a sudden, like I was saying before, this person has sleep apnea. But the provider entered in, 15 ICD codes in there, and a back condition was ICD code number 15. It's clearly not the reason this person got treatment, but CMS's algorithm caught it up like that. So if there are obvious ICD code things where we can identify, look, this clearly isn't related, we can tell based on the CPT code, the ICD code, the provider, something like that. That's easy. Sometimes it's not quite that easy. And this is really where, if you're referring this over for handling, you may need to provide more than just here's conditional payments, can you deal with this, especially if you have information that this is why we don't owe it. Because let's say you have a knee injury where there's a minor strain or a contusion and treated for years. 10 years later, because you still have ORM open, this person needs a knee replacement. You're like, whoa, we don't have anything significant that requires a knee replacement. If you have like a medical record that shows that, like you have a treatment record sent with a treating doctor saying, this knee replacement is not related to the industrial injury, which doesn't always happen, but I've seen it enough times where I'd say if you have something like that, just send it over with a referral, especially if you're having somebody else work that conditional payment. Just because if you have additional evidence, CMS will consider that and you could submit it with the appeal. Likewise, if you have any court orders, what the insurer is liable for and what they're not liable for, make sure that you're including that in any appeals as well. Also, does state law permit treatment? There are some states that say, look, in order to get work comp to cover the treatment, it has to be done by an authorized provider. So if an unauthorized provider is providing treatment, you don't owe that under state law. So you also want to make sure and highlight that, and you may need to provide proof of who the approved treating provider is to CMS in order for them to remove those conditional payments. We can move on to the next slide. We have kind of a part 2 slide here for best practices and tactics. But yeah, along with the court order, is the injury or condition in question denied? So either you might have taken this matter to a hearing and gotten a favorable court order, or you could have just denied it from the get-go and you accidentally reported that you accepted the claim in question. Again, it's not impossible to send documentation to CMS proving you denied it, but they may require more proof. They may say, okay, show us pay records or show us your denial letter, something showing that this was in fact an accidental reporting of the claim being accepted when it was in fact a fully denied claim. Also, more on the liability and the no fault side. Did coverage end? Are you no longer required to be the primary payer on it? Sometimes you need to look to the policy documents as to things like, does this liability or no fault policy only cover up to a certain amount? Is there a certain amount of time period that this person had to file a claim? Are they outside of that time period? Is the treatment they're requesting, is that something that's not covered by the policy in question? Work comp, it's probably more broad. You're probably not going to see a whole lot of limitations on this unless it's like a Georgia or something that has a 400-week maximum. But if you have a specific liability or no fault policy, you can look to those policy documents and submit that to CMS and highlight it and say, look, here's right in the policy documents, we don't owe this. Specific to no fault claims, I just want to highlight these a little bit just because we see some of these and it's usually more Section 111 reporting than not. But specific to these claims, you can enter in the policy limit. So if you don't enter in a policy limit, it looks like the CMS that you have an unlimited policy. So if it's a $10,000 med pay, enter in that $10,000 limit. Also, if you exhaust that policy, enter in that you exhausted it. You're basically telling CMS, here's how deep the well goes, and here's when the well ran out. So that's important to put in because, again, we can deal with it later, but if you don't do it at the time, it just means you're dealing with a conditional payment resolution headache later on. And then also entering an ORM termination date if applicable. So you're not going to do this on liability claims, but no fault and work comp you will. So if there is end of coverage, whether you settle the claim, court order, policy says you're done making payments after a certain amount of time, enter in that ORM termination date, because if you don't, CMS can come back later on and say, looks like we have payments related to this body part in question. So those are kind of appeal tactics and best practices, but there's also settlement documents that we want to consider as well. So I'm going to let Marty speak more to that.
Thanks, and we can go on to the next slide, Adriana. So settlement document checklist. So this is really the for everybody here, looking at how are you going to actually go ahead and settle these cases? And this is something that happens regardless of whether it's a liability case or a comp case. And you really want to start with one understanding in mind, and that is that when you're going ahead and settling this case and you still aren't quite sure what's going to happen post-settlement, right? We settle the case today and we think that the conditional payment amount is going to be X, and then it comes back much higher than anticipated, right? So because of the fact that you never really, truly know, or rarely do you truly know, you want to identify the responsible parties, who's going to actually take charge post-settlement, and have clear obligations and clear expectations for those parties post-settlement. So if I'm settling a liability case and I'm a defense attorney and plaintiff attorney says that he's going to take care of it. Michael's the plaintiff attorney in this case. He says, I'm going to take care of it on behalf of my client. When that happens, then we're going to set the rule where Michael has certain obligations post-settlement with regard to communicating with the contractor, communicating on behalf of his client, and then resolving the case. And it may be that we say that Michael's going to communicate back to me when he resolves it and makes payment. It may be that Michael says he's going to take immediately a percentage of the settlement and put it into his escrow account. All of those expectations and all of those expectations that we would have post-settlement for activities that are going to taking place post-settlement are going to be documented clearly within that settlement agreement and with clear understanding as to who's going to fulfill the obligation to make sure that Medicare is repaid. It may be the case that even though I'm the defense attorney, my client says, hey, we want to make payment. We've got a situation, we've got a pro se claimant in this case, or a pro se plaintiff in this case. We're going to make sure that we are going to be the one to take care of it, because what we don't want to do is have a situation develop where a year or two from now, technically speaking, Medicare can turn around and come after us. We want to avoid that situation. We won't have to make any double payment. So that's the first piece. The second piece, lay out the facts. Did you identify whether there were conditional payments in this case or not? If so, what was the amount identified? And then again, identify who's responsible for reimbursing Medicare, right? So this is really important. You want to have walked into the settlement with the understanding that there is an amount that's owed or not owed, and an amount that's identified or not identified. Have clearly illustrated the dates where the date of the letter, the amount of the letter, all of those things. You don't have to necessarily put them within the settlement agreement, but you do want to be able to know where those things live. And you want to bring that stuff to the table. You want to walk across the, walk into the negotiation room and sit across the table with somebody and say, hey, here's a copy of the conditional payment letter that we received on such and such a date, or we haven't seen that you have received a conditional payment letter. Now, one thing I want to point out to anybody who's going into a mediation and isn't quite sure, or is going to settle their case and isn't quite sure, the Medicare conditional payment portal, the MSPRP, is something that provides basically almost real-time information to pretty much anybody who has access to it. And even though we don't have to have a consent form from the beneficiary, we can oftentimes identify what's the conditional payment amount for you, right? So I want you to be aware of that and understand that. And if you ever have a problem, you're not quite sure, you can always pick up the phone, send an email, me, Michael, Neha, any of our local reps, we can immediately hopefully get you an answer if you ever needed it, right? And you may have people inside of your own organization who can do that for you as well. So that's giving you all the information you have so that when you go ahead and settle that case, you settle it eyes open. If 3 days ago Medicare sent out a letter and nobody received it, we can find out in the portal. Okay, ripcords. This is important. So within your settlement, you want to have a ripcord that you reserve all rights of appeal. You want to make sure that all parties reserve all rights of dispute and or appeal with regard to Medicare's conditional payments. A lot of times we've seen in the past where Medicare looks at that condition. Michael talked about Medicare wanted to see the settlement, the actual settlement agreement. If the settlement agreement company X or plaintiff Y is going to just pay Medicare, they're going to say sometimes, hey, you just got to pay Medicare. It doesn't mean that we can't overcome that, but it may be challenging for a layperson like a beneficiary to overcome something like that. Medicare, if you say, hey, we're just going to repay you no matter what, we have seen Medicare simply reject out of hand almost a dispute that might be more of a dispute that would be successful had there been a reservation of rights included. So reservation of rights is really important. Don't forget about that reservation of rights. Okay, now hold harmless language. Oof. Okay, this is one, Michael, I'll tell you what, hold harmless language. You've seen this happen before. Neha, we've seen this happen before. Hold harmless language can get people into trouble. There are states out there where the hold harmless language is something that if you put it in there, where you say, hey, we're going to, the beneficiary or the beneficiary's attorney is going to hold the carrier harmless, there can be a real problem. For example, Ohio has banned that language. I think it's Ohio, you may know off the top of your head, Neha. But there are a few other states that have basically banned that type of language in settlements with Medicare beneficiaries when Medicare conditional payments are involved. Don't rely on hold harmless language really to help you in any way other than to create sort of another reason to push the person or the entity that you're dealing with to act, right? Medicare is going to ignore the hold harmless language. They're going to say, hey, you're the claims payer, we're allowed to come after you, or you're the beneficiary, we're allowed to come after you. The law allows them to pick. They just happen to choose, typically post-settlement, to go after the beneficiary. But at the end of the day, they don't have to. They don't have to. They can go after anybody involved in the stream of payment in that settlement. One other piece of this settlement language puzzle is certainly the Medicare Advantage plans. Include actions taken with regard to Medicare Advantage if necessary, right? So Medicare Advantage is what? 50% of the overall population. Now, it may not be 50% of your claims population, but it is 50% of the overall population. So if you've taken any action with regard to Medicare Advantage plans, if you look at the query data and see that the Medicare Advantage plan in this particular case is Kaiser or Humana, Have you contacted Humana? Has somebody reached out? Have they been told that they are in fact going to settle this case? And now one thing that I'll also point out is that, when we talked earlier about the volume of Advantage plans out there, they're very challenging sometimes to deal with. And they sometimes say, hey, wait, we're going to wait until you settle the case. Sure, thanks, Marty, for telling me about this case involving Neha, but we really don't care about it until Neha's going to settle her case. And maybe Neha's ever going to settle the case. So they basically say, hey, we're not going to waste the ink on this paper and send you a conditional payment or a Medicare Advantage plan conditional payment notice. And so at this point, though, we're talking settlement language. You're going to go ahead and settle that case. So now is the time, certainly well enough in advance of that actual putting pen to paper on that settlement. Now is the time to contact these Advantage plans, let them know about the fact that you have reached time to resolve the case and you want to move on, right? So certainly you don't want to forget about that. And don't also forget about the waiver of the private cause of action, right? So private cause of action is a huge potential risk for a very, very small percentage of cases, and it doesn't really cost anything to have that thing waived. So we always mention that. We always recommend that be included as well. So with that said, I believe at this point, we are going to start to get over to Q&A. We've got about 10 minutes left in our presentation. We may have some questions, Adriana, but Michael and Neha, before we kind of move on real quick, is there anything that I missed in the settlement language area?
No, I think you hit the nail on the head. At the end of the day, it's just identify who these responsibilities belong to in your settlement documents, because if they're not clear, you just don't want to be muddy if there's a dispute later on.
Yeah, I agree.
Yep,
That's comprehensive. Thanks.
absolutely. Go ahead, Neha. Sorry.
Nope, that's good.
All right, we can move on to Q&A, Adriana.
All right, thanks everyone. So we only have one question, and that is, does a $750 settlement or less threshold still apply to traditional Medicare, where traditional Medicare would not be involved? Does it apply to MAP?
Ooh, this is a question. This is almost like a great debate question, because this is an area where we've seen the Advantage plans, and it's not just this area, but it's many areas where we've seen Advantage plans try to have their cake and eat it too. So they try to say, hey, we are an Advantage plan. We're just like Medicare, so we can file a lawsuit for double damages after this settlement and come after the carrier for tens or hundreds of thousands of dollars in an unexpected way, and we don't have to even tell you about the fact that you had a conditional payment in their eyes prior to settlement. And then we've also seen situations where they've said, hey, but we're not the same as Medicare. We are actually not governed by some of these things like the fixed percentage option, or we're not governed by the $750 threshold, right? And so, my personal philosophy on this is like, you can't have your cake and eat it too. Like, you got to pick a lane Advantage plan. And so I said, if you're really just like Medicare, if you're going to say you're just like Medicare, then you have to allow us to utilize the fixed percentage option. Period. That's it. That's non-negotiable. If you're just like Medicare, you have to allow us to utilize this $750 rule. If we're settling our case for $750 or less, then you have to allow us to say, hey, there's no conditional payment that's owed in this particular case. That's my own personal philosophy on it. That's certainly the way that we would recommend, that I'd recommend it. I mean, I know it's a personal philosophy. Thankfully, we don't have to deal with it too often. But, Neha, Michael, curious as to what your thoughts are on that as well.
Yeah. I mean, I agree with the philosophy for sure, and definitely kind of going back to the question in terms of traditional Medicare. If you have a settlement that's below $750, which we don't see a lot of those, but if you do, there's no reporting requirement, which would mean that there's no right to recovery on those claims. So I think utilizing those same rules to tie over into a Medicare Advantage plan really sort of seems to make sense. I don't know, Michael, if you have anything to add.
No, just kind of echoing that. And fortunately, if you're dealing with that situation, it's pretty low exposure as far as what your problem is. So that's the good news, at least.
Okay, well, thank you. We actually received quite a bit of questions in the past 10 minutes. I don't know if it was a glitch or anything like that. Sorry to everyone. We will not have time to answer them all, but we will answer them via email. I can promise you that. So let's try and get 2 more in. So the next question is, with regard to bundling coverages, CMS highlights the main code for each conditional payment. If that code is related, can we challenge the unrelated secondary codes that are included?
So I can take that one. So basically, on these conditional payments, like I was saying before, CMS identifies all the ICD codes that were reported with them. If the first ICD code reported is related to your injury, it's pretty hard to get out of that. So if you have a low back injury and ICD code number 1 is low back pain, you're basically going to have to provide additional proof to get away from that, because the way it looks like is the primary reason for the treatment was low back. If it's ICD code number 2 or beyond that, and the primary code is, let's say it was upper respiratory illness or something just completely unrelated, we usually have a high level of success saying, look, this person clearly came in for a respiratory infection and they just added a whole bunch of other ICD codes. Usually CMS will remove that. Not always, but if they don't, we could take it to the second level appeal and deal with it there. And most of the time, CMS will remove it. If they don't, or if there truly is it just got coded wrong and it's for something else, you may need to get actual medical records, which I get that can be difficult, especially if it's something that wasn't related to your claim. But depending on how valuable it is, if it's a $10,000 treatment, it's you might need to do some more legwork in order to get around that particular one.
Great, thank you, Michael. The next question is from Paul. If a case is referred to Treasury, does CRC hold its case and refuse to respond to a dispute until the Treasury sends the case back to CRC?
I can take this, sure. So basically the short answer to that is yes. So if Treasury has your case, if the case has already been referred to Treasury, that means it's past the 120-day window for the appeal to be filed. And if your appeal is filed after that date and the case is already at Treasury, you have to get it basically sent back to the CRC for them to be able to work it. That's the sort of the procedural mechanism to be able to do so, or to be able to have the CRC actually sign off on it. Now, one of the things that we didn't really cover too much here is, how can we get Treasury to actually evaluate the case, or how can we get a Treasury letter or demand, I should say, to be reduced? And there, if it's the case that you just didn't do it, that's not a great answer, right? But there are a lot of procedural reasons why you may, in fact, not have received notice. There may have been a reason why that conditional payment demand, for example, was sent to the wrong address. There's, myriad reasons why you missed the opportunity to file that appeal. If you missed the opportunity to file that appeal, then basically that's giving you a second chance to do it, and you have a right to be able to do that. So there are options once the case hits Treasury. We have pretty good success. I shouldn't say pretty. We have excellent success at eliminating debt that is sitting with Treasury. But in order to do so, you really do have to understand the ins and outs of that process, the ins and outs of how to get that claim sent back to, for example, the CRC as the underlying contractor, to get that demand ultimately reduced, hopefully down to nothing. And one of the things that we haven't really talked about today is what your success rate should be. So if you're handling these claims on your own, if you're looking at conditional payment disputes or appeals that you're filing, on behalf of no fault or workers' compensation claims, your appeal and dispute success rate should be well over 90%, because that's how screwed up some of these bundled codes wind up looking. So at the end of the day, you should be really able to knock most of these out, but that's the key, is how do you go about the process of doing it, and how is it that on an individual case basis you're able to demonstrate to Medicare that you're not responsible for that underlying debt.
Thank you for listening to this episode of the ECS on MSP podcast. We look forward to joining you next month for our next episode. For the latest updates and educational content from ECS, please visit our website at examworkscompliance.com. See you next time.